The Ecuador litigation against Chevron, I think, raises important issues and teaches important lessons across the board here for our legal profession, for our legal systems, for transnational litigation, for transnational business, for our global marketplace and our economy. I want to thank Nick and Matt and the editors, who I think have done a terrific job in putting this together, and it's really a great array of people here today. I've taken to heart Professor Hensler's plea that we not relitigate the case, but I am a litigator, so I'm going to rely on some of the documents, the arguments, the judicial rulings, and activities in the Chevron case to glean out 10 key lessons that I think we can learn from the Chevron case, as well as some of the other transnational matters I've been involved in, including the Dole cases that Mr. Arian was so kind to mention. I think the lessons touch on basically every issue that I'm going to talk on every issue you're going to talk about later today, including legal ethics, RICO, judgment enforcement, third-party litigation financing, transnational discovery, and arbitration. This case truly has it all, so I think it was a great topic for you to pick here, and I'm really glad you're doing it. I was disappointed to learn that plaintiff's lead counsel, Mr. Donziger, couldn't be here today, but I'm hoping that during the course of my presentation I will bring him to life for you. So through his words and through some of his memos, I think some of what he has said really are key to learning some lessons from this case. Let me start with lesson 1. When you tell a lie 1,000 times, it does not become the truth. You've just lied 1,000 times. It becomes a fraud. One of the most disturbing patterns that I've seen in transnational litigation matters is that U.S. lawyers, when they traverse the globe and go on crusades into foreign countries with weak or corrupt judicial systems, is that they act as though the usual rules of truth and accuracy do not apply. One of the questioners asked this point. I think the answer to your question is easy. You don't leave your ethics behind in the United States when you go into a foreign country. But perhaps because they're far away from home, or they think that American-style discovery won't apply and there won't be discovery, that they think the adversarial truth-seeking process that we have here in the United States won't apply, they determine that they can make false statements inside and outside the courthouse, and that becomes a major feature of the litigation strategy. And I think Mr. Arian, again, I'm not going to respond point by point, but he just repeated many of the statements that courts have found are false and that have no bearing in the evidence whatsoever. Now, I know this sounds pejorative and biased coming from a defense lawyer, but don't just take it from me. I base lesson 1 on the words of Mr. Donziger himself, who in an August 14, 2008 email to his co-counsel, Mr. Fajardo in Ecuador, said, in explaining why they needed to keep hitting these themes, if you repeat a lie 1,000 times, it becomes the truth. And, of course, that's just not true. But I think one of the lessons, and this is sort of a sad lesson, is that if you repeat lies and false statements, it can give the plaintiffs or anybody a short-term advantage in this kind of litigation. And I want to make clear, I'm not saying that every single case that is brought in a foreign country involving U.S. companies is the product of fraud. And I'm not saying that there shouldn't be remedies for people in foreign countries or in the United States when companies don't behave properly. That's not my point here. But what I've seen is this pattern, and the Dole cases were a good example of it, where the lawyers go to a foreign country, they start engaging in tactics and fraud and soliciting people who don't even know what the case is about to be in the case, and it becomes a fraudulent enterprise. And the judge in California, throughout the Dole cases, finding fraud, finding corruption, tainted those cases. And Mr. Arian mentioned Florida and suggested things didn't go as well there for us. A federal district judge, affirmed by the 11th Circuit, held that the judgments coming from Ecuador could not be enforced, and this one was a $100 million judgment because the Nicaraguan process didn't provide due process, didn't provide unbiased tribunals. So things went very well in Florida because the plaintiffs' lawyers had gone too far. They had exploited the system in Nicaragua in that case. Now, as we've laid out in our RICO case against Mr. Donziger and Mr. Fajardo and their team in the Chevron case, they used false statements about the conditions in Ecuador and about Chevron, or Texaco, which was the company that actually did business in Ecuador and then merged with an affiliate of Chevron. And I want to again commend Nick for a very good summary of 25 years or so, or longer. It was very well done. And what they did, and again, this is a lesson, and again, this is one I think I'm going to give you the lesson for all of you, and then I want you to forget about it and never follow it. But you can take false facts, some vivid images, and create a powerful, superficial narrative, which is what they did here in this case for many years. But they're internal files, and I can't emphasize this enough, and we have many of these documents on the website, the Amazon Post. I urge you all to go there. But judicial rulings from Judge Kaplan in the Southern District of New York, 8 different courts in the United States have found that these activities that the plaintiffs engaged in Ecuador were fraudulent and tainted the proceedings there. But these internal documents show, in their own words, that their strategy was quite explicitly to smear Chevron, to embarrass Chevron with false statements, with a pressure campaign before the media and before government bodies to create this false narrative to force a big settlement. If this is the model for human rights litigation going forward, to pick up on Professor Hensler's point, then I think we're all in a lot of trouble. This is not some sort of do-gooders out to help the world. There are billions of dollars at stake, and I'll come back to this, where it's funders, lawyers, investors are trying to make a fortune. So I think the lesson one is lies have a way of catching up with you, and this strategy of falsehoods is catching up with the plaintiffs in a big way in this case. Lesson two, if you are plotting to commit a fraud and to intimidate, bribe, and pressure corrupt judges, don't invite a camera crew to tape your every move. I wouldn't have thought that would have been a lesson that anyone needed to learn, but I think it's something that has been really an important lesson from this case. As has already been mentioned, Mr. Donziger and his team solicited in part, I think, to further the pressure campaign, the public campaign, which they talked about in all their internal files, this movie Crude. And as I mentioned, when I first got involved in this case, when I first got involved, Crude had just hit the theaters and it was out, and we saw things in the film itself that seemed like blatant wrongdoing. Mr. Donziger saying, we're going to play dirty. You'd never do this in the United States. We're going to go down and talk to the judge and that kind of thing. And so we thought, if that's what's in the movie, what's in the 600 hours of outtakes that Ms. Jo Berlinger, who you see on the screen, has talked about having? So we subpoenaed the outtakes in New York. Judge Kaplan granted our motion to get the outtakes, and the Second Circuit affirmed that, and it broke the case wide open because we had on film the very fraud and corruption that we thought was occurring there in high definition, very well shot video. And as one federal court observed, the outtakes sent shockwaves through the legal system. So we heard Mr. Arian talking today in really, really very vague terms, but you can't deny what's on the screen and what's on film. I'm going to play just a couple of clips, but I want to just address one very long clip, which I'm not going to play. It's when our associates, most associates don't like to review documents and engage in discovery, but everyone liked this project because they went through the outtakes. And when they found the video clip of the plaintiff's team, Mr. Fajardo, standing before a blackboard, much like this, explaining to the group, including the experts of the plaintiff, that, and there you see Mr. Cabrera, who was the neutral court-appointed expert, and my Spanish isn't great, but I think that's the global assessment of the expert. This is 2 weeks before Mr. Cabrera was appointed as the independent judicial expert. And on tape, they're plotting, and they say, we're going to write the expert report. He's just going to sign it. So this report had been, you heard a mention of $27 billion. Cabrera's report, when I came into the case, was being touted by Mr. Donziger, by their whole team, as super important because it was the court expert. This was the independent, neutral, court-appointed expert. This broke it open. We had proof that they ghost-wrote the entire report of this expert. They paid him into a secret account, and he just signed the report that they were then relying on before the U.S. Congress, before the SEC. Mr. Arian has become their securities lawyer. They had ghost-written this report, and that's no longer in dispute. Judge Kaplan, numerous courts have said the plaintiffs have no way to defend against this. We ultimately got their consultants' files, internal computer data, Mr. Donziger's computer, which shows that they had written this entire report that they claimed had been written by the judge's expert. Now, On this issue of proof, and Mr. Arian referred to this clip I'm going to show you. This was another big break for us because, a profanity warning is one of there. A couple of these clips have some profanity, but this clip, this smoke and mirrors clip, I'll call it, Mr. Donziger is being told by his experts from Stratus Consulting that the evidence doesn't support their claims. One of their big claims was groundwater contamination, and they're telling him we don't have the evidence. And here's what he says in response.
All the reports are saying it's just at the pits and the stations, and nothing has spread anywhere at all.
That's not true.
That's not exactly true.
The reports are saying that it's groundwater contaminated because we've taken samples from groundwater.
That's just right under the pits.
Yeah, but that is evidence.
Mm-hmm.
Well, you need
One thing that vision is see.
No, I
It's just right at the
hold
pits.
on a second. You know, this is Ecuador. Okay? You say whatever you want. At the end of the day, there's 1,000 people around the courthouse, you're going to get what you want. Sorry, but it's true. Okay? Therefore, if we take our existing evidence on groundwater contamination, which admittedly is right below the source, and wanted to extrapolate based on nothing other than our theory that it is, we average out to going 300 meters in a radius depending on what do you call it when the land goes down? The incline. You know what I mean?
Gradient.
The gradient. We can do it. And we can get money for it. And if we had no more money to do more work, we would do that. You know what I'm saying? Yeah. And it wouldn't really matter that much. Because at the end of the day, this is all for the court, just a bunch of smoke and mirrors and bullshit. It really is. We have enough to get money, to win.
That really, I think, captures it. He's being told by his experts, we don't have, this was a big argument that the alleged contamination had spread beyond the pits. They're saying it didn't, and he says it doesn't matter. And his reference to 1,000 people around the court brings me to another clip, which the theme that we saw from the internal documents, we got all their internal correspondence during this period, and it comes up over and over on these crude outtakes, is this notion of pressuring and scaring and intimidating the judges based on the recognition that they're corrupt and they fear for the jobs. And so their strategy was to scare the judges into ruling in their favor. Here are a couple clips that capture that motif.
And the only language that I believe this judge is going to understand is one of pressure, intimidation, and humiliation. And that's what we're doing today. We're going to let him know what time it is.
And then I think we have another clip about the judges and Mr. Donziger's view of the judges that he is going to intimidate and humiliate.
All the judges here are corrupt.
They're all corrupt. It's their birthright to be corrupt. Why? Because they get paid so little.
You know,
It's a culture. It's disgusting.
And I've asked myself many times, why would you as a lawyer, and this goes to some of your other panels on ethics, on just lawyering, why would you tape yourself? Why would you let camera crews tape you during this kind of thing? And I think it ties back to the first point, that some U.S. plaintiffs lawyers, when they go crusading into these foreign countries, start to believe the normal ethics rules don't apply. They think the ends justify the means. They feel above the law. They feel outside the constraints of U.S. law and our ethical system. They view themselves as global celebrities and not lawyers. And they forget that there are rules of law in the United States that do allow discovery. And I'll come back to that point, one of the questions went to, that will allow their adversaries to find the misconduct that they're engaging in. They think it's a free-for-all. And that's not right, and that's a lesson. It is not a free-for-all. The plaintiffs' lawyers in the Dole case also starred in their own documentary, and let me tell you, it did not help their case either. So again, an important lesson, don't film your wrongdoing, but an even more important lesson is don't engage in wrongdoing in the first place. Act ethically and honestly when you're representing your clients wherever you are in the world. Lesson 3, when you try to enforce a plainly fraudulent judgment, that is a fraud too. As has been well documented in the press, including by one of today's panelists, Mr. Goldhaber from the American Lawyer and Roger Parloff from Fortune most recently, we have amassed a mountain of evidence that the $19 billion Ecuadorian judgment is the product of fraud and corruption. And I wouldn't be here saying that if it was just me trying to prove my case. But as I mentioned, 8 U.S. courts have found 8 U.S. courts in the United States, federal district judges have found, and some appellate courts have noted, that there's no question that fraud in the Cabrera report that I mentioned tainted this judgment. That was ghostwritten from start to finish. And it's, in some ways, we have a lot of objective evidence that you wouldn't have in other cases, because the State Department has noted over and over that the Ecuadorian judiciary is weak and subject to corruption and subject to, very specifically, lawyers for a particular party authoring, ghostwriting the judge's decision, which is what we have now shown in our summary judgment paper that we filed last week in the RICO action. And Mr. Arian alluded to this, but he didn't deny it, and they never have denied it, that Judge Guerra filed a declaration in support of our summary judgment motion, explaining how he had once presided over the Chevron case. When he left the case, Judge Zambrano came in. Judge Zambrano ultimately issued the $19 billion judgment. And Judge Guerra says in his declaration that he was hired and paid by the plaintiffs to work with the judge. We have emails talking about paying the puppeteer. Judge Zambrano had Judge Guerra work with him on the judgment itself. So we're not talking about the report now, the judgment that Mr. Arian and the plaintiffs are touting. And if it weren't enough to have the declaration of one of the judges who he said they were promised $500,000 out of the ultimate proceeds if they let the plaintiff write the judgment, and so they proceeded with that plan. And he said basically the judgment that was issued was pretty much what the plaintiffs wrote with some editing by him. And it's not just that. We have documentary evidence, and this slide that we have up here is an example of our forensics. We have found massive quantities of internal documents from the plaintiffs, including what's known as the fusion memo, which I believe Mr. Arian worked on when he was a summer intern internally for the plaintiffs, that found its way into the judgment in large quantities, even though those materials were not filed in court. And so we have all kinds of evidence that the plaintiffs themselves drafted this judgment. We have documents on Judge Guerra's hard drive that show orders from the Chevron and other cases. Any one of these pieces alone would be compelling evidence of fraud in this judgment, but collectively they're undeniable. Now here's another question. In the face of that, in face of what I mentioned about the Cabrera report being ghostwritten, in the face of the videotaped expressions and evidence that we have of fraud and corruption, how could a lawyer from the United States or from Canada, in good faith, subject to their ethical obligations, try to enforce the judgment in the face of 8 findings by federal district courts that fraud tainted the judgment? How can they do that? I think it's difficult to understand. Particularly since once we started to expose the fraud, the lawyers themselves knew they were in trouble. One of the plaintiffs' counsel in Ecuador wrote an email that we obtained in discovery that said, if this comes out about the Cabrera fraud, Mr. Arian today suggested that's just how they do it in Ecuador. That's not how they do it in Ecuador. You don't bribe a judicial officer and ghostwrite his report. You don't do that in any country. But this lawyer said the proceedings we could lose, but we could all go to jail. Several law firms withdrew from the action at about that time, but Mr. Donziger, Mr. Arian, the Patton Boggs firm, and others have hung on to try to find some country somewhere to enforce this judgment. And 2 things are important to emphasize here. Chevron does not have any assets in Ecuador, but it has a lot of assets right here in California, very close to where we are right now, and in New York as well. But the plaintiffs won't come here to the United States because they know that this judgment could never be enforced in the United States. They've seen how federal court after federal court have reacted. And most countries will not enforce a judgment that's the product of fraud, that's the product of a system that lacks unbiased tribunals, and that lacks due process, which we think is exactly what we have here. So bottom line is, isn't it a fraud to try to enforce the judgment and collect billions of dollars in doing so? The answer and the lesson has got to be yes, and maybe at some point the lawyers in this case will see the light and understand that, and hopefully today as you talk these issues through, you'll focus on that question. If a lawyer knows he's got the ill-gotten fruits of a massive fraud, can they really take it around to other countries and try to enforce it without becoming tied into the fraud? I'm going to zip through the last 7 lessons a little more quickly because I think they all tie in to the first 3. Lesson 4, litigation is not the same as a political or media campaign. I think there's a lesson for everyone, and Mr. Donziger, again, I think, helps us with his own words. He declared in one of his documents, his internal documents, we can have the best proof in the world, and if we don't have a political plan, we will surely lose. But if we have mediocre proof and a good political plan, we stand a good chance of winning. And I think as a lesson for plaintiffs' lawyers, for defense lawyers, for all lawyers, litigation is different. We have different rules. We have ethical rules. We have to defend our clients. We have to zealously represent our clients. But it's not the same as a media campaign. It's not the same as a political campaign. Here's a clip. I think we have a clip of Mr. Donziger. No, he said it's not a legal case. It's a political battle that's being played out through a legal case. And just stepping back, I'll move out of my advocate mode for a second. I think this was a major, major bad maneuver by the plaintiff side here, because once they started treating this like a political campaign and lost their focus of trying to get evidence, of trying to get witnesses in science to prove their case, and started focusing on just ghostwriting things to put in the record so they could then engage in this pressure campaign, I think they lost their way, and it has been causing them major problems. As I said, while lawyers in good faith must be sensitive to the political and media ramifications of litigation in representing their clients zealously, treating a case like a political campaign or a media campaign can be dangerous, inappropriate, and it can be harmful to the clients in the rule of law. Lesson 5, science and facts matter, including when you are litigating in a foreign country. I'm not going to go into detail on this one, but the first thing I would say is if the evidence was so strong for the plaintiffs, why would they have had to engage in this fraud? Why would they have had to write the report of Mr. Cabrera themselves? Why would they have had to intimidate judges? Why would they have had to write the judgment itself if they had such great evidence? The reason is they didn't. You heard this, Mr. Donziger, when his experts told them that they didn't have the evidence. Smoke and mirrors were in Ecuador, which, by the way, shows a bit of disrespect for the country and the people that he's supposedly trying to help in terms of how he speaks about the Ecuadorian judiciary. But there's all sorts of evidence that we got after the fact through discovery that showed that other experts were telling them, we don't have the evidence. This is one of my favorite. This is a handwritten note from Ann Mace, who you saw in that Smoke and Mirrors clip. After meeting with the lawyers, she says, proving damages would be preferred, but it's not necessary. And it wasn't necessary because they just wrote the report of the damage expert from the court. In fact, Ann Mace and her company ultimately were the ones who ghost wrote it. Another expert, Mr. Kalmbacher, testified later in the discovery we took in the United States that a report that the plaintiffs had submitted under his signature, they tacked his signature onto it, was not his report. They were not his conclusions, and in fact were the opposite of what he had concluded. So they forged his report. Another report, Mr. Russell, said, beseeched, he quit and told the plaintiffs to stop using statistics and data from his reports because they were not accurate. So if the science were on their side, this would be a different case. But instead of recognizing that fact, they doubled down and went with the media campaign and the smear campaign to try to get a huge amount of money. Thank you. Lesson 6. Even if you're litigating a foreign tribunal, discovery is available in the United States. Section 1782 of 28 U.S.C. allows discovery for use in a foreign proceeding, and the plaintiffs here litigated for many years thinking there would never be any discovery. No one would ever be able to find out what they were up to, what they were doing. But the truth will find you wherever you are, and that's what's happened. Lesson 7. Multinational companies need to be more effective in advocating for the rule of law in countries where they invest. And this goes for advocacy before the State Department, the U.S. Commerce Department, Congress, in the United States seeking treaties, seeking trade agreements and the like. In our global economy, I think it's crucial for things to function in a way that companies can do business around the world but have some assurance that the rule of law will be applied. That's why I think this arbitration in The Hague, which I know the last panel today is going to talk about, is so important. In that matter, Chevron argues that because of the fraud and other issues, the treaty prevents enforcement of any judgment and requires Ecuador to prevent the judgment from being enforced, and also that Ecuador itself is responsible for any damage award because of the settlements and releases it entered into with Texaco back in the 90s, and when Ecuador then took over oil production completely at that point. And just yesterday, the arbitration tribunal ruled in an interim award that Ecuador has violated international law by facilitating, quote, the finalization and enforcement of the Lago Argrio judgment within and outside Ecuador, and it ordered Ecuador to show cause why it should not compensate Chevron for any harm caused by its violations. Ecuador has continued to either foster or at least not stop efforts to enforce the judgment, notwithstanding prior orders of the tribunal to help prevent enforcement and to avoid violating international law. Lesson 8, U.S. plaintiffs' lawyers are exploiting poor, uneducated citizens of foreign countries. A big part of the plaintiff side narrative in these cases is that it's major U.S. companies that are going into foreign countries and exploiting the populace and the lands. I think Professor Kimmerling may talk about some of these issues and her views about it. She's written about it. And we certainly could have a debate about those issues, after we live in a country that was founded when people from another country came and took over from the indigenous people. So it's a broader question, but it's not one that can be resolved through global tort litigation like this that's financed by hedge funds and internet gambling impresarios who are living offshore and the like. This is not the way to address those questions. Moreover, companies like Chevron today have strong social responsibility programs. It's the plaintiffs' lawyers who are doing the invading and exploiting with little regard for their supposed clients. Mr. Donziger, again, gave us the real rationale for the lawsuit in one of the clips from Crude.
This is a plaintiff's law to make fucking money.
And I think that really is the corrupt part of this case. Professor Hensler, your question, I think, sort of, and I'm not suggesting you were siding with me on this, but you were getting at this. Is this really the future of human rights litigation? I don't think so, and I hope not, because I think it would be bad. And I know I just have a couple minutes left. I'll wrap up here. Maria Aguinda, who Mr. Arian mentioned at the outset of his remarks, when she came in, we have her on a Crude outtake saying that she thought she was signing up for free medicine when she was first signed up to be the plaintiff in this case. The lawyers in these cases work hard to turn their cases into political and social movements in these countries. And as Justice Cheney in the Dole cases that I handled said, it's sad because they whip up a frenzy of antipathy towards Texaco or Dole, and the populace begins to think that all the problems of society flow from that company or a group of companies, and that the lawsuit is going to solve all the problems, and that's just not correct. Which brings me to lessons 9 and 10. Number 9, lawsuits brought by U.S. plaintiffs' lawyers and funded by hedge funds and other third parties do not benefit the local communities. The money here, we had discovery from Burford Capital, one of the companies that funded the lawsuit that's now withdrawn and accused the plaintiffs of committing a fraud on them, by the way. So again, it's not just Gibson Dunn, it's not just Chevron, but here's just a pie chart in this big human rights case of the billions of dollars that are going to be split up among all these folks. I think that's probably set some kind of record for something called human rights litigation. But the tribunal made the point yesterday as well that the funds here are not going to the people. And in all these internal documents, all these computer files we've looked at, not one mention by the plaintiffs' lawyers or their team how they would use the recovery to help fix the problems they're seeking to remedy. And I'll finish with lesson 10. If you don't have the facts, you are not allowed to create the facts. And this, I'll just end with 2 clips. You can't make up the facts, but here's what Mr. Donziger first told his experts and then told his interns about what you do when you don't have the facts.
I once worked for a lawyer who said something I've never forgotten. He said, facts do not exist. Facts are created.
And here's another one. Now he's with his summer interns. You law students, this is wrong advice.
We need to make facts that help us, and the facts that we need don't always exist. This is another key point about litigation. have to get the right facts. And if they don't exist in an obvious way, you got to go figure out how to make them. Otherwise, you're going to lose.
I think those quotes speak for themselves, and I'll just conclude by saying, as lawyers, we need to vigorously advocate for our clients. Sometimes there's no black and white, but we have to act ethically. We have to act zealously. I don't think that this business model is going to be a popular one now that we've exposed what's going on here. I don't think, as Mr. Arian says, this is going to be the wave of the future. And I don't think this type of litigation is going to make the world a better place for anyone. Thank you very much for listening.
Okay, so we have 15 minutes again for questions. Marty, were you raising your hand? Or, okay. All right, Harry, you want to lead off again?
Conversation, but I will push you on the thought that there's something wrong with the plaintiff's counsel trying to enforce the judgment. I mean, I think you have to start by agreeing to disagree with the plaintiff's lawyers on whether the judgment achieves justice. So, but start with assuming a plaintiff's lawyer who believes there has been a serious environmental harm and serious wrongdoing by a defendant, and who then gets a big judgment in the plaintiff's favor. For the plaintiff's lawyers to enforce that judgment, or to try to enforce that judgment, to me seems like a no-brainer, and to that lawyer, it seems like the pursuit of justice. And the fact that there have been courts that have said this judgment was obtained in various ways that are tainted, and let's take as a given that there are courts that have said that and that there's evidence to support that, I'm not sure why that makes it some sort of Rule 11 violation or other fraudulent or unethical conduct for a lawyer who believes in the justice being done by that judgment to then try to go pursue it.
See, I think that really is, it's a great way to put the issue, because that, to me, crucial. I think it's an easy answer. Think if you're in the United States and you think, my client has been injured. I know this evidence that I have is false. I know it's fabricated. But I know he's been injured, and I know that the defendant did something wrong. But I can then go, I didn't fabricate the evidence. I know it's false, though. Every reasonable lawyer who looked at it would know it was a fraud. But because I know justice will be achieved, I think it will be, I can go to court. You would be sanctioned. You would probably be thrown in jail. You would be in big trouble. And I don't think there's any different here. And if you go with, I went with your hypothetical that he believes justice is going to be done, go with mine. If every reasonable lawyer would look at the record and say, this judgment was ghostwritten by the plaintiffs, this judgment is the product of fraud and corruption and bribery of the judges. Assume that's true. Every reasonable lawyer would do that. You think that then that lawyer could say, but for the greater good, I can go into courts and try to get this enforced so I can get money. So I, the lawyer, can get billions of dollars. You think that's appropriate?
Isn't there a difference between putting on false evidence and then judgment and saying truthfully, this is the judgment of the Ecuadorian court that's been upheld on appeal through that court system. We want you to enforce it. Okay, and then the issue is before the U.S. courts or whatever courts on whether they'll enforce it. But it's not, to say truthfully, this is the judgment of those courts is quite different from putting on a witness or presenting a document that you know is false.
I don't think it's different. I think it's worse, because it's like fencing stolen property. You've got a tainted thing, and we're not talking about chicken feed here. We're talking about billions of dollars, and we're not talking about altruism. You heard Mr. Donziger. You've seen the funding here. This isn't to try to make the world a better place. This is being funded as a business enterprise. But to take something you know is the product of fraud and go into court, in most of these cases, you're going to have to defend it as being legitimate. You're saying this is something that a civilized nation should respect because it's the product of a system that is fair. If you know that it's the product of fraud, I would invite every one of you. I think some of my clients may be here, they may object to this. You want to sit down with the evidence? I'll walk you through every piece of evidence, and I guarantee you will say, the science doesn't support the plaintiffs, this is the product of fraud, and I know you wouldn't go into court and try to enforce that judgment. I can bet you.
So, Ted, I want to ask you a question somewhat akin to the question I asked Graham, a big picture question. And I'll put it hypothetically so that you don't have to answer with regard to this particular case. So you're representing a client in a factual situation like as Texaco was, given your experience in this case, question one, would you still file a motion to dismiss on forum nonconvenience so you could go to a court with potentially the same kinds of issues that seem to be associated with the Ecuadorian court? Question two, if in fact the US Supreme Court in Kiobo rules that there are many of the cases of this genre have no jurisdiction in US court, shouldn't get jurisdiction in US courts, and if the courts in which companies like Chevron do business are, as we've described, weak democracies, weak courts, etc., where are plaintiffs with legitimate claims supposed to go?
Two excellent questions. On the forum nonconvenience point, it's interesting, I argued this Dole case that I mentioned on enforcement of the judgment there, and the first question that one of the judges asked me was, this case is about be careful what you ask for. Because at the time, in the Nicaragua cases in Ecuador, the systems were pretty stable and the judiciaries seemed pretty good, but things change. And so I do think that's a question now companies are looking at differently. They've seen what happened, and I know it's a different equation. And I think more those cases, for example, some cases are being filed under state law theory. So some of the Dole cases, others, the argument is that there's a state claim. And the judge in the Dole case, before the judge threw it out after the fraud came through, allowed it to go to judgment based on the state law theory. On your second point, which I guess that links to, I guess there's two points. I don't really think that we need, I mean, I think it's a somewhat patronizing attitude that the world needs Steve Donziger or Graham Arian or Patton Boggs to go help them litigate matters in their country. I think it's suggesting that these lawyers can solve all the problems of the world, and I don't think that's true. I think it creates all these risks. They're not members of the Ecuadorian bar. They're not members of the people the communities who live there. So it's a meddling, and it would be one thing if they were really doing it for human rights purposes to make things better for the people. But when they're doing it as this investment vehicle where they're trying to make billions of dollars as a profit-making enterprise, I don't think we need to look hard to try to figure out a way to keep this going. So I think there are remedies in the countries. We don't need U.S. plaintiffs' lawyers and hedge funds making a business out of this. And I think that and as I said, I am not someone standing here saying people shouldn't have a remedy. I'm not saying there shouldn't be, if there are issues here, again, I could get into the merits of what's going on in Ecuador, but it's been 20 years since Texaco was there. The government of Ecuador has been operating there for 20 years. The President Correa has said, a lot of the problems are in the water, the problems are caused by lack of sewage treatment efforts. Petroecuador has a terrible record of safety, but does that mean that we shouldn't, as a Chevron and other companies, shouldn't try to make the places better where they do business? No, it means that companies should be socially responsible. But I'm telling you, this kind of lawsuit, this kind of, I'll just use the word shakedown because I think that's what it is, that's not the way to get there. And I think that the way companies look at the world these days, there are other alternative ways, other solutions to help people to be more responsible. But this kind of litigation by profit-seeking plaintiffs' lawyers is not the solution. Back there?
Bert, you had a hand up. You want to speak and maybe identify yourself?
Hi. My name is Bert Newborn. I'm visiting here at Stanford from NYU this year. You make a devastating attack on the plaintiffs' lawyers, and if you listen to what I just heard, it's very disturbing. I have this terrible intuition, though. I mean, you do a wonderful job. You're a great lawyer. That we're getting asymmetric facts. I mean, what we are getting is an asymmetric picture of what really should be characterized as a plague on both your houses and a real disgrace to the way one should attempt to deal with these issues. When Texaco moved the case down to Ecuador, you say they had a stable judicial system. What they had was a right-wing government where the right wing ran the courts, and then the politics changed in Ecuador, and the left wing then ran the courts, and Texaco found itself in a very unpleasant environment, but it was an environment that it created for itself. When you take under forum nonconvenience and you move cases like this that would challenge the most established and strongest judicial systems in the world, and you put them into forums like Ecuador, which does the best it can. I don't want to libel the Ecuadorian judiciary. They do the best they can with the resources they have. But you give them the effort, and you insist that they take this huge animal and run it through their courts. What do you think is going to happen? Both sides resort to inappropriate behavior in an attempt to get the judgment. And I think that's what happened here. I mean, I don't know what to do. It's too late. We're in the quicksand where both sides have done it and no remediation has taken place for these poor people. But the one thing I do know, this is not a model. This can't be a model. But it can't be a model just because the plaintiffs screwed up. It's a model because the defendants screwed up as well. This is an appalling way to go about dealing with an issue like this. And so, I mean, my sense is, in the long run, both sides will be hurt, and what we should be doing is not having conferences like this, where both sides continue to lob artillery shells at the other. The focus should be on how do we end this damn thing now, providing some remediation for the people, and get on with the business of trying to bring better lawsuits in the future.
Well, a couple things. One of the things I think, first on the question of what do we do with Ecuador and why is the case down there? I mean, on the one hand, it's an issue in Ecuador. I mean, again, I hear what you're saying about the system, and it's difficult for those systems to handle that. But Mr. Arian made a point about Texaco and a judge. There's never been any evidence of wrongdoing by the Texaco lawyers or by Texaco back in the courts and misconduct. But your point is a good one, the looking forward point. That we need. That's why I think this is a great conference about how do we not have this be the model, because it's not good for anyone to be in this situation. But it's not an equal situation, Professor Newborn. In fact, Mr. Goldhaber's piece I think last week or this week talked about this. At some point, we have been making these arguments about the fraud now in our courts, in our system, by the plaintiffs. This is right now. This isn't some ancient history and debating what happened back in the 60s and 70s. It's happening right now, and it's undisputed. They've never disputed the evidence of their own fraud with the judgment or with the expert report or any of these other activities. But your broader point, I think, is a good one, and we've said we think that it's Petroecuador has been the entity running those oil operations there for years. But we've offered to talk with Ecuador. We have this arbitration with them to try to see if there's some way to at least address some of the issues, because there are problems there. So it's not like I'm disagreeing with you that there's got to be a better way. I completely agree with you with that. But I think one of the problems, I think we've seen a lot of media coverage as well, the plaintiffs say that's false. They put out a press release. They have this press person, Karen Hinton, who will put out a press release. If we win, she puts out a press release saying we lost. So truth goes out the window, and there's this equivalency, but this isn't one of those cases. And I hear what you're saying. Like I said, I wouldn't be here making these comments if it was just me arguing the evidence. We've got admissions, we've got court rulings, but the bigger picture issue is how do we deal with these issues and how do we avoid this kind of thing going forward. But I think this is an issue, again, it kind of goes back to this notion that we, the United States lawyers, have to be the ones who solve the problems in these foreign countries. I just don't think that's the answer, but I do agree with you that if we can maybe not have a rerun of this, it would be very good. So I appreciate what you're saying. And it's nice to have you in California.